Hi, my name is John Goralka. I'm the founder of the Goralka Law Firm. We work solely and exclusively in estate, business, and tax matters. We're here today to talk about what may cause your trust to fail. Just a month ago, the Supreme Court ruled that individual retirement accounts that are inherited from a parent or other person are not protected. They are not considered to be funds that would otherwise be protected under the bankruptcy code. So as a result, after those funds are received on your death, those funds are subject to creditor claims, divorce, and those issues. The other issue regarding retirement accounts is really what the benefit of a retirement account is. A retirement account is actually a very special type of account where it actually grows on a tax-deferred basis. The IRS doesn't want to give you a free ride forever, so once you hit the age of 70.5, then you're required to take distributions. And those distributions are typically referred to as required minimum distributions. And after 2003, the IRS liberalized the rules regarding who qualifies for those very liberal required minimum distributions. We refer to that as a stretch out. And the key is being able to pay the taxes over a longer period of time. And one of the concepts to think about is if you asked any chief financial officer of any company when they would like to pay their bills, the simple, easy answer is later. And the way to look at a retirement account is you want to make sure you enhance the ability for your beneficiaries or your loved ones to pay their taxes later. So that way the accounts continue to grow on a tax-deferred basis, providing a mechanism to pass very significant wealth to later generations. For example, if you start with a $250,000 IRA, which is actually a very modest account, and many people, when they look at that, if that's an inherited IRA, sometimes people will look at that and think, gosh, that is a $250,000 IRA, but I need to pay tax on that, so really it's only worth maybe half of that, or $125,000. But really that is not really the most appropriate way of looking at that. And certainly that is the case if there's an immediate withdrawal. But on the other hand, instead of actually withdrawing all of the funds from the account, if the funds remain in the account, still subject to the control and advice of your financial advisor, so that way it continues to grow on a tax-deferred basis, then that $250,000 account is worth much more. And in fact, if a 50-year-old child inherits a $250,000 individual retirement account, that child is going to be able to take out $700,000 in required minimum distributions over a 30-year period. That is very substantial. And then at the end of that period, there's still going to be almost $300,000 left in that account. So the true value of that $250,000 IRA is not the $125,000 net after tax if you pull the money out immediately, but really is really almost $1 million, which is the $700,000 taken out in required minimum distributions, coupled with the $300,000 that would remain in the account at that time. So your planning must really focus on the ability to provide for that. And so again, we refer to that as preserving the stretch out. Part of the problem is a misconception. Many people feel that they can run those retirement accounts through their regular trusts. And the way they do that is they would designate their trust as a beneficiary of that retirement account. However, most living trusts will not qualify to meet the very stringent requirements under the Internal Revenue Code to be a designated beneficiary. The result of that is that now it's going to be subject to be paying tax over a 5-year period. And instead of being the stretch out, I really refer to that as the blowout. Very much like a tire getting a flat and going flat. We've lost all the air and the ability to travel. And so the key is preserving the stretch out. When you have an individual retirement account from an estate planning perspective, you have 3 choices. The first choice is to name the individuals as the direct beneficiaries. And if we do that, they may or may not actually choose to defer tax when the time comes. Many of my clients refer to that as the instant withdrawal system. They have access to the funds, and so they withdraw the funds. And then the problem with that, of course, is instead of enjoying the stretch out, the substantial growth, they've lost all of that, very much like a tire deflating. And so also, the concern is if we name the individuals, we've seen mistakes happen. And what that is sometimes the individual that doesn't know what to do, they contact the plan administrator, they say there's been a death, the plan administrator says, send me a death certificate, and once the death certificate is received, they send a check. And if the individual receives that check and they deposit that check, that's it, it's over. And the issue is with a spousal rollover, if there's a mistake made, you have a limited window period of time to correct that mistake. That is not the case with inherited IRAs, so that is over. But on the other hand, now if we look at it from an asset protection standpoint, if we name the individuals as the direct beneficiaries of the retirement accounts, they do not enjoy any asset protection for those funds whatsoever. The Supreme Court ruled that inherited individual retirement accounts do not qualify for asset protection. Prior to that, there was a split of authority within the courts. So now we know that there's no asset protection with respect to individual retirement accounts. On the other hand, we can list your living trust as the beneficiary of those retirement accounts. If that's the case, the living trust is not going to qualify for stretch out in most cases. On the other hand, we can build within that living trust the personal asset trust or other protective provisions so that we can protect those funds from creditors. The price, of course, is we've lost all of that future tax-deferred growth. The best approach, perhaps for many people, is to utilize an IRA Inheritance Trust. And an IRA Inheritance Trust is actually a living trust, a revocable trust that is established solely and exclusively for your retirement accounts and your individual retirement accounts. With the IRA Inheritance Trust, we're able to actually set a date when the beneficiaries can get control of those funds, and that date may be 45 as it is for my children, or 50. And so with that, we are actually able to ensure that they're going to make the right decision, that those funds are going to qualify for the stretch out until they hit the appropriate age. So no instant withdrawal issue there. Also with the IRA Inheritance Trust, we're able to build in the asset protection provisions to protect those assets and funds from divorce, from lawsuits and creditors, and to help shelter those from estate tax. A much better approach. However, the IRA Inheritance Trust is a separate trust. And so because of that, it really makes sense, economic sense, when the aggregate funds on deposit within those retirement accounts exceeds $150,000. We've now discussed some of the many issues that may cause your living trust to fail. If you have any questions about how these or any other issues may apply to your estate plan, or if you need an estate plan, please feel free to call at 916-440-8036. Click here to subscribe and see more videos on asset protection, estate, and tax issues.